Hi, welcome to another edition of the Trustcast Show, and we're really happy to have with us David Scopp. Did I pronounce that correctly, David?
You did, and that's a rare accomplishment. I hear all sorts of things.
I'm sure it's
They
Scoop a lot of time. People probably want to say Scoop,
Goop
or
and Scope, and it was originally Scopovich when my family entered the United States through Ellis Island, and they cut it to Scop. But I think perhaps would have had fewer mistakes with Scopovich. I don't know, but anyway.
okay. So today's guest spent 20 years inside the legal system, defending insurance companies at one of America's top firms, winning personal injury trials, and working as a research attorney inside a California courthouse before walking away from it all to build something completely different. David, when did you first realize the way most people do estate planning is actually setting their families up to fail?
So yeah, I wanted to start at the beginning, like you said, out of law school. I went to a big law firm because that was kind of what you're supposed to do. And I eventually realized that I'm not a fighter. I have a counselor's heart. So that led me to estate planning. But now I'm getting to your question. Even there, I realized that something was missing, and it was transactional. It was about the documents, and it was about the next client. And what I realized is that that process wasn't protecting families, and the plans would often fail. So yeah, and it's just more about an ongoing relationship.
So, so I have just kind of some general questions. So people say, okay, my parents have a will, aren't we covered?
So yeah, that's a great question. A will does do a lot. It lets you appoint the person to administer the estate, which is called an executor. You can waive bond, you can decide who gets what, but what it does not do is avoid probate. And probate is expensive. It's public, so anyone can see your will or your assets, and it's time consuming. It takes a long time, sometimes in California up to 3 years.
So, yeah, what happens in California when somebody dies without any plan at all?
Well, that would be called dying intestate, and so there are default laws under the probate code as to who gets what, and again, just like if you have a will, it would be probated, but the court would have to decide who the executor is. So a judge is making that decision for you, and then the the state of California has a plan for you as far as who gets what.
So, so how long does probate take? I guess I'm probably asking you for the state of California because every state has their own rules about this, don't they?
That's right, and it even varies based on the county in California. But it's long, and it can take up to 3 years. I would say it's in that 1 to 3 year range generally.
So obviously, you must have another alternative to probate. So why don't you talk about what you usually suggest to help families so that they don't have to go through that lengthy process? I mean, somebody died, and then the person who made the will, they're thinking, I'm passing on, all my properties to these people. We're going to divvy it up. I wrote it all out, and then they think, okay, well, everybody's taken care of. What's the mistake there that you can correct?
So the first thing is to sit down with the client or clients and find out what their goals are, because perhaps avoiding probate isn't a goal, or maybe they don't have a situation where their assets would require probate. But so that's one thing, and then my goal is to demystify the process so that they have clarity as to what would happen, and then what they would want to change about that. And so if one of their goals is to avoid probate, then Generally, I would recommend a revocable living trust, which is a document. And the other thing we would do is spend time organizing their assets, because that document does not achieve the goal of avoiding probate unless it is properly funded, which means that we have to understand what assets they have and make sure the assets are retitled properly.
So, if when do you know whether you should be doing a revocable living trust versus when you just, either you don't have enough assets to worry about it, or what's the cutoff there? I mean, everybody has their own cutoff, but what in your mind is the cutoff between when somebody would be better served by having a revocable living trust versus a will?
So, and again, this is a personal choice, but to simplify things in California, if you have approximately $200,000 worth of assets, it's a little bit less than that, but just to simplify things, and or you have real property. And so those are kind of thresholds that I use.
So let's say if I live in the state of California, I don't, but I visited there many times.
Okay.
But if I lived in the state of California and I wanted to, protect my heirs so that everybody got what they were owed with the least amount of hassle, and let's say I own my house free and clear, or maybe I own just half of it and the bank owns the other half. How do I retitle things so that is a workable solution? And don't you have to have cooperation from the bank to make that happen?
Yeah. So let me just make sure I'm understanding your question. So you're asking
I mean, it's
basically,
hypothetical.
right. So just that, I mean, of course it varies. So you're asking basically how to make sure the assets are properly titled in the trust. Is that what
Yes. Yeah.
yeah.
So
And
like
that's,
if I own still have an
so
outstanding mortgage.
yeah, well, that's actually doesn't affect the process. But one of the most important things, which takes cooperation between the attorney and the clients, is just identifying the assets. And and one reason is what we're discussing is you can't retitle them if you haven't identified them all and listed them. Um, the other reason to do that is sometimes heirs don't even know what assets you have, and they end up cheating to the state, so they're lost. There's nationwide, there's about $50 billion of lost assets that have gone to the state. But so once you've done that, then it depends on the asset. So it's, I mean, this is a case by case thing, but real estate needs to be deeded into a trust. And there are things in California you have to look out for. You need to make sure there's no reassessment when you do that, and there's other considerations. Bank accounts, like you said, you just have to work with the banks and have them retitle the accounts in the name of the trust. And I mean, it goes on from there. But there's certain assets that actually you don't retitle, such as retirement accounts and life insurance policies. You have to make sure that they beneficiary designations are proper, and that gets complex, especially with retirement accounts.
So if you have a retirement account like a 401k or something like that, you don't retitle it, but how does it go into your trust, or maybe it doesn't? How does that all work?
Well, yeah, and now you're getting the complexities, especially post Secure Act 2.0 regarding retirement accounts. But you have certain goal if you want to extend the stretch period, which has tax benefits. You might put the spouse as the primary beneficiary and the trust as the contingent beneficiary, but that also depends on your goals as far as if it's a blended family, you may want more control over what happens. In other words, you may want to let the spouse use it in trust, but ensure that your biological children get it afterwards. And in that case, you wouldn't put your spouse first. So there are competing factors there. So yeah, does that answer your question?
It does, but I want to dig a little bit more. So I'm just thinking of, the people who are interested in this topic. they probably are thinking the same things that, or I'm trying to think of what they're thinking as they're listening to the podcast, and and I kind of let my curiosity do the leading on. So I have pages of FBI dossier on you, not really FBI, but we do a lot of research. But I end up that I always kind of, my own curiosity is it helps. So I'm curious as to, you're talking about it. So a lot of people do have blended families, and you brought it up because that's the case where someone was married and they have children from their first marriage, and then but now they're with their second spouse, and then something happens, or they want to plan ahead when something happens, and the one spouse wants to make sure that his or her children get whatever a portion of is California, by the way, as a community property state?
It is, yes.
And so how does that work? So if the spouse, if it's a community property state, how does that work with a trust?
In the case of a blended family. So the first thing again is counseling. So you're discussing the different options with the family, and you see what their goals are. But assuming you have a blended family with each spouse coming in with their own children who want to provide for the surviving spouse, but then make sure that their respective biological children are provided for basically equally, or you could say the children and stepchildren are provided for equally. Is that what you're saying? How would you do in that case?
Yeah. How do you do that?
So it's called a Clayton election, and it's basically what you're doing is instead of giving all of your share of the assets to the surviving spouse in what's called a survivor's trust, which is fully revocable and amendable, you divide it up into 2 or 3 trusts, depending on the situation. So the survivor's share of the community property would stay in the survivor's trust. The decedent's share I'm sorry, let me correct that. The survivor's share of the community property and their separate property would be in the survivor's trust. Let's just say that half to simplify things. The decedent's half would be in those 2 or 3 trusts, which would be for the surviving spouse could use for their benefit during their life. But it is already determined what would happen after the surviving spouse's death, and presumably it would be to the children and stepchildren equally. But that trust for the benefit of the surviving spouse, there's different levels of control you could give the surviving spouse. So again, it's about counseling and educating the clients and seeing what they want.
How difficult is it to set this up, and how expensive is it?
And so it's not difficult. I mean, my goal is yes, the law is nuanced and technical, but my goal is to demystify the process and take my clients through it. I mean, how expensive it ranges as far as expensive, but it's a lot less expensive than probate.
Yeah. So if I go into at the end when everybody's gone and you go into the having a will and probate versus having a trust, let's say I have a $3 million estate, and I want to leave that behind to let's just say both spouses are gone, this hypothetical example, and I want to leave that behind for my children in equal measure. What is the net difference between, I know you can't give me an exact, but what would be an approximate net difference between going through probate and having it dispersed through a revocable trust?
So in California, probate, the attorney's probate fees it's statutory, and it's based on a percentage of the estate that's kind of a sliding scale. So, but it's about 2 to 2.5%. and then the executor has their fees basically. So I estimate about 5% of the estate. So on your $3 million example, that would be about $15,000. Setting up you described a very simple trust.
Right.
It depends on the county in California, but I don't know, 3,000 to 6,000 might be a range. They go up from there because when you're adding asset protection, some of these nuances with blended families and other things, it can get a little bit more complex.
So, I've seen these things just go south too when you're doing with a.
And I'm sorry, my math was completely off. I'm sorry. It would be 5% of. I'm getting nervous here,
of
but
3 million. Okay.
Yeah, so that's 150,000.
Yeah.
Right. Because
Okay.
5% of $1 million is 50,000. Yeah.
I should have latched onto that too. I just kind of let it go.
Yeah.
Yeah. So there's a gigantic
huge
difference.
Yeah.
So and the other thing is I've seen these kinds of situations go south when something goes into probate and everybody lines up with their hands out because it was the 3 children, but then there's nephews and nieces and cousins and parents, and it seems like sometimes it can go sideways. Have you seen that happen?
Yeah, of course. I mean, and trust and estate litigation, unfortunately, is growing. One of the things I mentioned earlier was one of the disadvantages of probate is that it's public as opposed to private. And when things are public, creditors and potential heirs come out and start making claims. So that's right.
So when you're in the trust, this can all just happen seamlessly without. So how long is it? So you said a trust can take up to 3 years, and then how long if you're?
No, I said probate can take up to 3 years.
Probate. I'm sorry. You said probate
Yeah.
can take up to. So how long? I messed that up. So how long does it take to execute a trust in that? In
to
comparison?
execute a trust?
Yeah. No, I mean not to get
To
it started.
administer.
So you administer it. Yes.
Yeah,
After someone's gone.
And that varies too based on the assets and actually what complicates trust administration is emotions. So beneficiaries can still delay the process, but if things are going smoothly, it's months. I mean, there are no court required procedural. I mean, basically, like probate court has a very set procedure with lots of filings and then delays because the court has to review them, and you're avoiding all of that.
So I was asking you how much does it cost to set up a trust, but how much does it cost to do the pro? Oh, you said that's the about
Probate
5%.
is
That includes
it's about 5% of the size of the
Okay.
estate. And another thing to mention is because one of the complexities you brought up is whether someone has a mortgage on their home or not. It's based on the gross value of the home, so it doesn't even matter. So when you're calculating the size of an estate, it's just the fair market value of the home, not the equity.
So, what does your life and legacy planning process actually look like? Walk me through, first conversation with you.
Yeah, so it's a 2-hour process, and what we do is we talk about kind of some of the questions you brought up, but what would happen? What's the state's plan for you, or what would happen under the law without a plan? And if there are minor children, we also talk about who would take care of your kids. What would happen, if something happened on the way home from this meeting or that sort of thing. And then we talk about whether that's okay, that plan, and then what they would want to change about that. And then basically at that point, if they want to design a plan, we go through the design and we ask certain questions, like what do you want to happen at the first death, and then what do you want to happen at the second death, and of course there are more specific questions within those categories.
So why do you think so few people actually do this? I mean, as a percentage, I mean, there's a lot of people who do it, but as a percentage, it's not a lot. So why do you think people don't follow through and do this? And so there's, probate is the majority. It's far and away the vast majority, and setting up a revocable trust is the minority. Why is that when it's so favorable to both the people who are going to be passing on and their descendants?
I mean, that's a really important question. It's a good question, but I think one is none of us want to face our mortality. It's a hard thing to look at and we're actually planning for incapacity too, but we look at terrible stuff happening to you. And actually, it's my belief that doing that can help us live more fully because we start to appreciate what matters. Another is education. I think what you just said about probate, a lot of people they just think, oh, it's not that complex, or it's not that bad. Or maybe people are not thinking that it's really not about them, but it's about their loved ones and making things easier for them.
Mm-hmm. So, how do you figure out what kind of plan that somebody really needs? So during this 2-hour process, exactly what happens?
I mean, and again, it's a counseling process because it's their decision. It's my job to help them clarify what they want and explain what would happen without a plan. But it's ultimately, I mean, it's a conversation. And I
So
do have very specific questions I ask. And once we get to, a decision, like we want to do a revocable living trust, then I take them through it, basically like a very detailed design interview. And then,
So do you also litigate? So like if a family came to you after a death and do you do any of that, or is most of yours the pre-planning and helping people to understand why they want to do a trust and how to go about implementing that?
So I think you asked too. I do not litigate anymore because like I said, I have the heart of a counselor, and I'm done fighting. I want to help people avoid court and conflict. But I think maybe you were also implying the question: do I administer estates? And yes, yeah, yeah. But if there's litigation, then that part would be referred to litigation counsel.
Okay, so can you have probate without litigation? Is there such a thing?
Yeah. Well, I don't know how you're thinking of litigation. I mean, it involves court, but it's a non-adversarial court process.
Okay.
Which I do. Yeah.
So you do help to administer probate. It's just that if there's some sort of a lawsuits that are flying, contested, then that's not your ball of wax, so to speak. Let me see. Tell me about a family that came to you in crisis after death, and what did the situation look like, and what happened. You don't have to tell me that names or anything like that. You just a situation where you were able to help a family that kind of surprised them.
A recent one was pretty large estate with many commercial properties, and basically it was actually so it was a beneficiary who came to me not trusting the trustee because the trustee was an aunt, and it was actually a situation where it's just sort of educating them on the process and the required notices and disclosures and that sort of thing that helped quell them. That was just a recent one, but and it was just facilitating conversation and gaining alignment there that helped.
So give me a case where you discovered someone's existing plan wasn't going to work and caught it before it was too late. Maybe you've had a situation like that.
Well, that happens all the time, because when people come to me, I catch, for example, assets that that would require probate that aren't in the trust. And what one of my sort of life-changing stories was before I was doing this work, when my mother-in-law, who had paid $8,000 for a very complex estate plan with probably great documents, but there were issues with the titling of property. So probate was required in it was a different state. And my wife and brother ended up having, conflict. It wasn't litigation, but there was conflict that still to this day hasn't been resolved. So that was that, and having children and seeing that the planning's about them were two of my sort of inspirations for doing this work.
Mm-hmm. So how long have you been doing the financial planning, the estate planning part of? How long has that been your primary practice?
I started meaningful legacy law in it was about June, so not even a year. However, I did earlier in my career. I was at an estate planning firm here in Monterey for about 2 years, and then did it on my own for several years after that. So in total, I've done about 4 or 5 years of estate planning, depending on how you count it up.
So people think estate planning is only for the wealthy. Where does that idea come from, and is that wrong?
It's definitely wrong. I think it comes from sort of what we've been talking about today. It's just lack of understanding of who would be, like, I guess, the value of avoiding probate, and also anyone who has minor children, in my opinion, should be thinking about estate planning, so that there's a plan for their kids, and not just appointing guardians to take care of them, but also deciding when they get access to assets. Where does it come from? Probably the idea that it's only for those with large estates who need complex, I guess you'd call it advanced tax planning, And right now, the estate tax exemption is $15 million per spouse. So I guess if you thought planning was just about avoiding or limiting the estate tax, you might think it's not for me unless I have over $25-30 million.
Right.
But there, of course, first of all, there's other taxes you can talk about, like capital gains, but there are other reasons besides tax planning to do an estate plan.
So let's talk about capital gains. Does doing a revocable trust have any bearing on capital gains? Are there? I mean, once you die, it depends on the state what the taxes are on your estate. Isn't it mostly the state and not so much the federal government?
Well, so going back to the estate tax, certain states have their own death tax or estate tax. California does not. So I was talking about just the federal one.
The federal government.
The issue I most frequently see with capital gains is it's a date of death adjustment for the basis. So say you buy a house in Silicon Valley in 1980 for $100,000. That's your basis, and then you sell it in 2025 for $3,100,000. Your gains there, your taxable gains are $3 million. So you're going to get taxed. You're right, and there's a federal capital gains tax and a state one, so that depends on the state. But you're taxed on that $3 million. There is a date of death.
So my next question was, so if you sold it, but if you died and left it to your descendants, your beneficiaries, then that changes, right? And you were just about to explain that.
That's where I'm going. So there's a date. It's often called a step up in basis because the assumption is it's going to be stepped up. The basis is going to be stepped up from 100,000 to 3.1 million. It's really an adjustment to the date of death value because it potentially could go down too. So so basically there's that. And then if the heir sold the house, now there's no gain to be taxed on because the basis is 3.1 million and you're selling it for 3.1 million. So a revocable living trust does not necessarily change that, but that's one of the, when you're planning for the estate tax, for example, or you want to have control or asset protection, you could potentially lose that benefit, and you're balancing, you're basically weighing those factors. I'm trying not to go. Well, okay. If you want let's say you want to give your kids a lifetime asset protection trust, which could be it could be, it protects them from divorce, creditors, bankruptcy, lawsuits, etc. If it's drafted correctly, and there's a lot of nuances there. But if you do that, the assets in that trust are not usually in their estate. It skips their estate. So if you skip an estate, there's no step up in basis at their death for the grandchildren. But there are also ways to tweak that so that with it, for example, a testamentary limited power of appointment, you can ensure that they have pretty good asset protection, but the creditors could potentially get it at their death or get some of it. And you also get that step up at their death.
So you really need to hire somebody like you to figure all this stuff out.
I'm just trying to keep this conversation simple today, but you're going deep.
No, it's good. It's because this is what people are thinking about, when they're going through this topic. They want to know. Some people just have a very simple estate, but others, it can. I think what I'm taking out of this, and correct me if I'm wrong, it can be more complicated than it appears, even for someone who has, particularly in really states that have had high appreciation in real estate. It can become more complicated to retain and pass on to your beneficiaries, to your family, what you thought you were going to be able to simply do, than it appears on just surface level.
Yeah, and again, my goal is to help simplify and clarify the process, but it is something that you should have counsel in going through. It's that's right. You said it well.
So you described training in mediation, mindfulness, and yoga.
Mm-hmm.
How does that actually change the way you practice law?
I think it helps with alignment. So again, in a situation with a blended family, I can address red flags and do it in a way that's not offensive, but bring it up and help the spouses discuss these important issues. So that's one. I also offer family meetings sometimes when there's siblings preparing for their parents' death, and they may have issues that are still, issues from childhood that are coming out now. That sort of thing can be helpful with that. And then lastly, in all honesty, it helps me it helps me balance the demands of being a lawyer. Having those practices, and it's a very rewarding profession, and I feel like I've gotten a lot of meaning out of it and helped a lot of people, but at times it can be hard. And so those practices help me keep on going and give the best service I can.
So you're a father as well. So did having kids shift how you think about legacy planning?
Yeah, I have two boys, and they're just the love of my lives, and it started making me think about them and realize that planning is not really about me. And it's about, I start to realize that some of these potential problems and complexities could affect them. So I guess it made me realize how important it is, which is important to me. I want to do work that matters.
So you published a law review article. This is going back about the Endangered Species Act in law school. So you've always cared about things, bigger issues. So we'll talk just a little bit about that.
You really did your research.
Yeah. I told you I got the FBI dossier here.
Yeah, you do. No, that was what, in 2005. But yeah, I've always been inspired by nature. I mean, I'm a surfer. I go backpacking, and I just really appreciate open space and protected land. And in college, I studied Emerson and Thoreau and was inspired by transcendentalism. And so I guess I care about our world. And I also love legal scholarship. So I wrote that article on the basically at the time, the constitutionality of the Endangered Species Act under the Rehnquist Court, which was the Supreme Court at that time, was threatened. And so I was writing an article exposing that, but also making an argument that it really was constitutional and it was essential to preserve biodiversity.
Well, it must have resonated. So what do you want your legacy to be now at this point? You're still a young guy, though, so maybe that's not the best question, but it is a question out there. What would you like your legacy to be?
It's funny that you're asking that, because that's something I demand of my clients, and I even offer legacy interviews where I can ask them questions. I record them and ask them questions so that their loved ones can see that and they can pass on not just their assets, but maybe their values and stories and that sort of thing. I mean, I think it's really, I'm going to sound corny, but it's really about love. I mean, it's about my children and wife and friends, and as well as provide a connection with community. That's been a big motivator for starting Meaningful Legacy Law. It's connecting with families, and some of them have minor children like our family, and some of them are in an older stage with adult children, but helping guide them and helping them avoid court and conflict. And then there's something with nature there that we just talked about, but that's just a big part of what inspires me, and I'd like to make an impact there.
So how old are your boys?
So we started late. It was nice of you to call me young.
You're younger than I am.
I just turned 50. But yeah, my youngest is 5 and my oldest is 8.5. And we were actually just camping down the coast. We're in Monterey County, so down the coast is Big Sur. We were just camping down the coast with 2 other families and our boys. So there were 7 kids and 6 adults and 3 dogs.
Oh wow!
Yeah.
So it's kind of a side commentary. My dad was 45 when I was born, so exactly the same age that you were when your youngest was born. So I don't think that's old.
Oh, thank you. I feel better now.
My dad used to go out Boy Scout camping. We went hiking. He did it all. So you got lots of good years in front of you, I'm sure, David. So what's next for Meaningful Legacy Law? Where do you hope this to? What do you hope to happen with your practice?
It's funny because I don't have these goals of building like $1 million practice or something. I mean, of course, profit matters, but really it's being able to have a practice that that allows me to have ongoing relationships with my clients and also support my family. So, it's X amount per month, I guess, but it's my goal is to deliver excellent service and have ongoing relationships with my clients. Those are my two goals.
I think we were just going to wind it up right there. That was great. I really appreciate you coming on the show, David.
Thanks, Zane. You have a great show. I appreciate what you're doing as well and appreciate this opportunity.
Thanks.